Happy Sunday, everyone. Hope everybody's having a good week. This morning, like we are every Sunday morning, this week talking about relocations. So, good morning.
I'm not even awake yet.
No, the time change snuck up on me. I figured it out around midnight last night and was like, oh, so that's gonna happen. And I'm still in pajamas and on my couch because
You just live there.
because nothing else is going to happen at this point in time for me at all. Um, but you and I had very busy week this week.
Yeah. Yeah.
I have been trying, like, because I know that people are like interested in what our week looks like. So I was looking back on my calendar this week to see what I even did because I honestly couldn't even remember what my week was filled with. And I, again, was in mediation for 4 days this week and in trial for 1 day. So it was like 2 weeks in a row of the same exact thing. And you and I had a really lovely time on Friday together, staying in mediation for 13 hours.
13-hour mediation. I still haven't even recovered. My past week, I had 3 trials and also mediated. How many times did I mediate? I mediated at least once. 3 trials, our Friday mediation, but then I had another mediation. That's what my whole past week has been with.
I know it's been really crazy busy like the last 2 or 3 weeks, but I feel like it kind of happens that way for some reason. Like there'll be a little bit of like slower downtime and then it picks back up in terms of like mediation and litigation.
Yeah.
But and it's funny because like you don't think about when you own a law firm, when you're an attorney and you own the firm, that you don't just have like mediation and court appearances. Like it, I think that's what people think your life looks like, but in fact, like the mediations and court appearances and hearings and stuff, like they take away from this whole other big chunk of our job, which is like to actually manage clients' cases and get them to move along. And so it's so hard when you have these weeks and then you're like trying to fit in how to email and call people and update them and plan and plot and other things in between it all.
Yeah.
So
It's a lot.
crazy busy, but one of the things that you had, it was actually not this week, it was last week, but it's what kind of sparked me to think about doing this today was relocations. And before I even say anything, like let me try while we are on live on Instagram not to get in arguments on our Instagram page. But that is about what is happening right now because yet another time I have this person saying repeatedly that child support is like fraud by the state, that it's state sanctioned, stealing, that the state is taking the money. And I'm like, I again, just confused people. When you pay child support, just so you guys know, the state is not getting a dollar of your money. It's going to the other parent. I promise you, if the state's taking anything, there's a little teeny tiny $5 administrative fee if they're doing things through the depository. Otherwise, the money goes from one parent to another parent. I'm just saying, you guys, I'm going to let it go at that. But just so you're aware, that is really actually the truth. And I happen to be in Florida, but that would be true if I was in 49 other states too.
Yeah.
Because that's just not what child support is. Nonetheless, back to relocations. Sorry, I was getting comments popping up again on my screen from this person who is adamant that child support's going to the state. Relocation. So you had a relocation trial 2 weeks ago, and I mentioned it last,
Yeah. It was like 10 days ago. Yeah, last weekend.
And I mentioned it last weekend, and I was thinking, relocations for certain are like the hardest thing that we deal with in family law. And they're hard for a lot of reasons, but number one is there are a lot of procedural requirements. So I thought we should probably start by breaking down some of those.
Yeah, but I want to make sure, like going back down to basics, what is a
Oh
relocation,
yeah,
right? So,
that's an important one.
yeah, that's why I do the teaching.
That's
So on
why
the
they pay you the big money, Nath.
that's why they paid me the big money to do these courses and to teach. Yes. So a relocation in the state of Florida is when one of the parents wants to move more than 50 miles from their current residence. And so what's important to understand is this only really applies when there's already been some sort of court order, some sort of time sharing, something that's already happened. It's different when you haven't been to court and people are wanting to move. And so all these requirements are only when there has already been an order entered or when there is a pending case. So for example, a petition for divorce is pending and all of a sudden now, months into the case, one of the two parents wants to move more than 50 miles. So that would trigger the relocation statute. Even if they haven't finalized the divorce, there's a case pending in court. So when you want to move more than 50 miles, you are required to either get the court to allow it and get you, an order allowing that, or you could do it by agreement of the parties, right? Because the reality is if you have the other party agreeing, you could do whatever you want.
But it
So
is important. One piece of it that you didn't say yet, and just to make sure we don't gloss over it, is the statute used to read that if you were moving the child more than 50 miles from their residence, now it actually reads the parent. So it's really if you, the parent, are moving, it's not just necessarily looking for the child to move. There's probably 15 minutes of conversation that could happen on that wording of the statute, but just it's important to note that this is true if you are moving and you are a parent and there's a court proceeding happening or there's already a court order in place for time sharing, then you have to comply with the relocation statute.
And again, like I end up focusing on like the basics, right? So when we say parent, yes, it applies to the parent, but it also applies to anyone who has time sharing with a child. So for example, if there's a grandparent who was given temporary custody.
You had that just as you were saying that, I remembered. That's true.
I have had every version of a relocation that I could think of. So when a parent who has had temporary custody then wants to move more than 50 miles, they would need to comply with the relocation statute, right? Because in essence, but the point of relocation,
a non-parent. You just said parent.
That I did
a non.
I meant grandparent, like a non-parent, like a person who has temporary custody. Because what the entire point, obviously, is that the courts don't want people leaving when there is another human here who should or could or has time sharing with this child to then make that, more difficult for them, right? So that applies if you have any sort of custody, time sharing, whatever court order arrangement, whether you're the parent or not. So I just wanted to clarify all that.
And I'll add, I guess we're literally just going to sit here like we clearly do a lot of relocations and this stuff comes up a lot. But the other thing that just made me think about is the 50-mile requirement. We're in South Florida and 50 miles is a very long distance in South Florida to live away from one another. I am in a case, I was in mediation on it this week. And one of the parents wants to move 45 or 44 or 45 miles away in South Florida. In South Florida, 45 miles could be like a 2-hour drive. I mean, literally, like who knows how long it's going to take you. And because it's not 50 miles, it does not trigger the relocation statute. And so if it's not more than 50 miles, you're not going to have to comply with the really strict procedural requirements of the relocation statute, although there still may be significant repercussions from it, right? Because it may not be in the child's best interest. Schools may need to change, your parenting plan may need to change, but you're not stuck under the super strict requirements of the relocation statute unless it's 50 miles or more as the crow flies. So we don't like put it into Google Maps and see how long it's going to take you to drive there or how far the distance is on a
Yeah, because
drive.
people take different routes. It has to be literally from one point to the other, like one
Yeah, like a
straight line.
straight line on a map.
Yeah.
All
The
right.
other
So yeah.
thing, the other thing that I wanted to mention is it also doesn't apply unless you are intending to permanently move, right? So for example, some
We
people
have
take
that
extended
case.
summer vacations. We have that case too.
I
People,
have the one that I have of that. The mom literally went to Tennessee, but she would her parents had a house here, and she left her address on her license as her parents' house, and she would fly back at least once a month for a weekend, and then say, I haven't permanently relocated.
yeah. So there has to be like basically an intention to live elsewhere, right? And so the statute says that you have to be gone for at least 60 days for it to be considered relocation. So we have a lot of people playing that game, right? Where they come back, like you said, they come back, they stay here for a little bit and they leave. But the statute is clear that it's not going to apply to anyone who's taking like an actual vacation, right? We take an extended summer vacation, whatever it is. That's not what we're talking about. We're talking about people who are actually moving, buying houses, living elsewhere.
And also
so I also want
not
to make that
military
distinction.
people. Like if you're stationed temporarily somewhere, we're not talking about that either. It's like an actual legitimate move.
Yeah. So, in terms of the logistics, you have to file a petition to relocate. You have to serve the other parent, and you have to then there has to be a response within 20 days. And one of the things that has also happened is it has to be a very specific response. So that's when people who try to represent themselves can make a big mistake. It doesn't look like just one of our regular answers. People see the answers that say admit, deny, and that's it, and that's all I have to do. Or I just have to, submit some paper to the court. The statute's very specific on how you need to object, right? And it's just not an answer. You have to object properly in order to prevent a relocation from occurring.
Right. You
Similarly,
can't just say
the petition.
no, right? Like you can't just
You can't be
text
like,
the person,
no,
I don't agree.
No, there has to be like specific language. There has to be, certain things in order to object properly. But at the same time, the petition has to be done properly, right? You need a proposed parenting plan. There's lots of things that on both sides have to be done correctly because, again, the courts take this very seriously. You just can't come in and just file anything. So on both sides, there has to be very specific terminology in the petition and in the response and objection to the relocation.
Yeah, the rules are really strict. I was just talking to one of our clients about this last week. The rules are so strict on relocations and are so well defined. It's not like other areas of family law. And what Naz was saying about filing your answer and a specific objection, if you don't do that, if the time has come for you to do that and you don't do that, then there is a provision of the statute that says the court shall grant the relocation unless there's like good cause not to. And the way that that's interpreted is like the overwhelming majority of time, if you don't object, if someone asks for a relocation properly, notices you properly, and you do not file your objection, then the court's going to enter an order allowing the relocation. So that's it. That's a confusing piece of it on some level, but it's part of like how strict the requirements are under the statute for relocation.
So the other thing that I wanted to make note is a lot of times when someone's asking for a relocation, it involves some sort of employment, right? So you go and you want to relocate to Georgia, but Georgia offered you a job and they're not going to hold that job indefinitely. They're offering you a job. So the statute also allows for some pretty quick timeline happening on this relocation, right? So you can file a request to have a relocation temporarily granted, and the statute says you can have that or should have that hearing, right? Like it shall happen within 30 days of you filing your request for a temporary relocation. Now, that's what the statute says. My voice is like not doing well today. But the problem is, logistically, in some of our counties, getting into court to have a hearing within 30 days is almost impossible, right? Like absent some sort of emergency. So that's something else that has to be thought of and balanced and figured out what you're going to do about it, right? So that is for a temporary. Now, for a final, the statute says it should happen within 90 days. Again, even in some of our counties, that is a big ask of the courts, right? Because they're just filled up. I mean, I was in court the other day, and I think the judges were giving out, I think, trials in November, right? Like 7 months from now on a trial, when people have all kinds of issues, right? Things that are happening. Some people are still living in the same house and they're trying to get divorced and they can't get into court for months and months and months. So the timeline, the purpose of that is because of, partly because of that, because if people need to move, they have certain things, right? They have to know whether they're going to close on a house in Georgia or not. Again, they're not going to hold the sale forever. Are they going to put in for a new job? Is that job going to hold that position forever and ever? So there are things that require things to move a little bit more, quickly in a relocation than in other cases. So that those provisions do exist within the statute. Whether we can get you into court that quickly or not really depends on the county, depends on the judge, depends on the division, depends on your set of circumstances.
Yeah, in my experience, it doesn't end up working out that way very often. And one of the reasons for that too is that even whether you are at a temporary relocation hearing or at a final relocation hearing, there are 13 factors in the relocation statute that the court has to take into consideration in determining whether they're going to allow the relocation or not. And again, our statute in Florida is really specific about relocation. So it literally says that the court has to make written findings of fact as to those 13 factors. And it takes time to go through 13 different factors and prove to a court that the move is in the best interest of the child. If you're successful in proving that the move is in the best interest of the child, then the other side then has an opportunity to prove that it would be detrimental to the child. So even though it's a temporary hearing, these are not quick hearings, and it's really hard to find time on a judge's calendar for anything that is significantly lengthy.
Yeah, and a lot of people think that they can go into court and say, for example, I get these calls all the time. Well, it's too expensive to live in South Florida.
Oh, yeah.
I mean, constantly, and it's cheaper elsewhere. Well, we all know that, right? Like every single human being and the judge know how expensive it is to live in South Florida. But unfortunately, that in and of itself is not going to be the reason that you walk into court and get a relocation. You have to have all these other factors in your favor, and there has to be a good reason, right? Like the courts take very seriously this relocation because they know it's going to impact the time sharing of the other person, of the other parent. It's going to be a big deal. So some of these factors, obviously, like financial considerations is one of the factors. We get that. If the kids are older, sometimes their preferences can be taken into account. But then a lot of people think, oh, my child wants to live with me in Boston, so that's enough. No, again, it's one factor. One of the biggest factors I tell people that they have to be very mindful of, and you have to do like with some, it really has to be thought out. The judges want to see that the parent who's moving is going to facilitate a relationship with the parent who is staying. And that is big. That is not just saying, sure, like that's fine, they can talk on the phone, or no, you have to really, really work something out so that that relationship is not impacted. So sometimes I've told clients, look, for you to win this relocation, you're going to have to offer more time than the parent already has. They're going to have the whole summer. Whereas before, you split the summer with them, or you had most of the summer. These are things that you have to do and go above and beyond. Another thing that has happened is the client who's moving has also offered to pay for all the travel expenses associated with it, right? Because they don't want to burden the person who's not moving with the move. They're not the ones moving. Why should they pay for anything?
But those it is important to say about that piece that the statute says that the travel costs can be allocated between the parents, and that you can take that into consideration in child support, which is interesting because we don't normally have the things that alter child support, but with relocation travel costs, we can do that.
Yeah. So everything else is really along the lines of why are you moving? What are you going to do when you move? What's the time sharing going to be? What's the other parent going to have, right? And how it's going to affect the child, right? Because unfortunately, the impact it could have on a younger child would be different than it can have on an older child, or even from one child to another.
Yeah.
There are a lot of considerations, and again, that ties into what's in the kid's best interest. Is this child going to be affected negatively for this move?
Yeah.
What ties do they have here to the community? Some kids have doctors and therapists and all kinds of things and wouldn't adjust well to a move that big. So those are all things that you have to be able to present to the court and prove, if you want to relocate, that it would be in the best interest of the child.
Another point that I want to go back to about it's too expensive here, I need to leave because it's too expensive to live here. So most of the time we talk about child support not really having an impact on time sharing or not really having an impact on your parenting rights. But this is one of those places where it's a little bit different because the relocation statute actually specifically takes into consideration if a parent is behind on child support obligations that are court ordered. So if you are a parent who receives child support and the other person is not paying you the support that's been court ordered and is behind and is not keeping up with their obligation, and you're looking to move because it's cheaper to live somewhere else, you have other living or work opportunities somewhere else, that is going to work in your favor in a relocation because the other parent's not complying with their court duty to pay the child support.
And it also applies for alimony also, by the way. Like the statute says, child support, marital support, all of that. So any financial obligation that person has would be a factor. Also paying like marital debt, like if you're post-divorce. So all of those financial obligations that person has to be up to date on, and if not, then it goes in your favor. The other factor, which isn't as commonly used, but I actually did have a very, very difficult relocation case with this factor, is in terms of any sort of history of substance abuse or prior domestic violence. So if the person who's trying to leave is able to prove that the parent who is staying has a serious drug or alcohol issue or has caused domestic violence or there's a pending injunction, those are things that you are allowed to enter into evidence, and it's literally one of the factors that can be considered in granting the relocation. I had a case years and years ago where it was so sad. Mom had dad was in prison, and he was in prison because of violence. And as a result of that, he was also the primary breadwinner. So there's mom without a job, hasn't worked, literally loses the place where they're living, loses her car, gets repossessed, like literally has nothing and has nowhere to go but California, where her parents are. And so it was a very heavy hearing because of all the emotional factors and all these things that dad had done and all that. But obviously it was granted and mom was allowed to go. I mean, dad's literally sitting in prison, not paying her anything because he's in prison. And there's this horrible history of like domestic violence and all that. So again, it really depends on each situation, which one of the factors may be, more focused on at the hearing. But you really have to touch on all of them because at the end of the day, it has to be in the child's best interest.
Yeah, I mean, at the end of the day, again, relocations are so specific and they're so fact specific that it's hard to sort of give a general, like, this is what you need to win kind of thing. Having said that, there are certain things that I think are going to seriously set you up for success on a case more likely than on another case. Like if the other parent doesn't have substantial time sharing already or isn't using their time sharing, if you have a job offer somewhere else, if you got married and you've been married for a while, have other children, and your spouse is getting relocated, there are some other, factors like that that I think can kind of seal it in better for you. But these cases are hard. They are hard to win. Judges don't like making these kinds of decisions. And we talk on here a lot about do it yourself and helping people do it yourself. This relocations are not a thing you do it yourself on. I mean, obviously, if you have no option, we'd be happy to coach you through it to the best of our ability. But there's certain things that you just need to have a lawyer for, and relocations is definitely one of them, because it is, again, like you can't emphasize it enough. It's so procedural and so strictly procedural.
It is. And, you know, one of the things that's in the statute, which also has to be said, is one of the reasons why a judge could deny a relocation is if the parent relocates before they have permission to do so. So again, it goes back to, you know,
important. I forgot to even mention that today. I'm glad you said that, because we have that now, but there's it happens a lot that people move and then they're like, oh, well, now I'm living over here. And we're like, well, you can't just do that.
You can't do that. I mean, I have people who call me and they say, I've already moved. What do I do now? And I'm like, that's not good, right? It is definitely a factor. Now, could it, just because you moved, be denied outright? No, but it is a reason why it could be denied outright. So it's definitely a factor. The other thing is, you can have the temporary relocation granted and allowed to relocate, but at the end of the day, you still have to prove at a final hearing that it's in the child's best interest. You still have to go through all your factors. You still have to be able to basically retry the whole case to determine whether or not it is appropriate for the child to be part of this relocation. And the fact that you were allowed to temporarily relocate in and of itself is not going to just get you a final relocation. No, you have to go through it all over again.
I have never had it happen in all of the years and all the relocations I've done. I've never had it happen that I won at a temporary hearing and then lost at a final hearing. But it's ostensibly possible that could happen. And then you're packed up and moved, and now you're gone and you're moved, and the judge at the final's like, yeah, no, it's not in the child's best interest. And then what? Like, you're either quitting your job, selling your house, and moving back so that you're not away from your child, or the child is primarily going to stay here.
Yeah, and I can tell you, I can very clearly see why that would happen, because one of the factors that I think the judges like really prioritize is if you're going to facilitate a relationship between the child and the non-moving parent, right? So if you move, let's say you move to Tennessee and you got your temporary relocation and 6 months go by and you have not facilitated time sharing, you have not allowed phone calls, you are not bringing the child, you're not following the court order on your temporary relocation. If that happens, you better believe a judge is going to say, no, you've got to actually come back. Yeah. You have to come back.
This is not
you know, and then it's sad, because the point is you need to make sure that the parent who's here still has a relationship with the child, a meaningful one, not just like a phone call a week. It has to be a meaningful relationship similar to what they had before you relocated.
Yeah. All right, guys. Well, that was a long bit of information on relocation on this Sunday morning, but we could probably do a whole other Sunday on it, because there's so much to talk about when it comes to these cases. If you guys have questions specifically about relocations, send us a DM, and I'll try to do a video and answer them for you. And we'll see everybody next Sunday.
Happy Sunday.
Bye.